Yes, Mr. Stanley.
So, my Lord, could we turn to clause 15, which I think your Lordships have been looking at page 27 of the supplementary bundle.
You can. Of the sub.
Of the supplementary bundle, I think so.
Yeah. Got it.
Now, if we pass over the except for the warranties defined in Exhibit 4, that shall be transferable to the customer, I'll come back to that. This contract shall not be assigned or transferred. Now, assignment obviously is a technical word, which suggests a particular mechanism of transfer. Transfer, however, is a non-technical word, which suggests any form of transfer. In other words, a lack of concern with the mechanism. In whole or in part, well, again, clearly intended to cover the transfer of any contractual rights, not simply the assignment of the entire contract. So, again, broadening words, if one is asking what was being prohibited. Then the words by any party to any third party. Obviously, we are very much focused on the word by any party, but there are also in there the words any party, in other words, this cuts both ways, but also to any third party. No carve out for any particular third party or any particular category of third parties, as one will sometimes see in such clauses. For example, carve outs for financiers, and no carve-out for insurers. For any reason whatsoever, the words that my Lord Justice Coulson referred my Lord Friend to, and again, broadening words, the parties do not care why the transfer takes place. They have in their sights all transfers by any party to any third party. Then, without the prior written consent of the other party, now, 2 points about that. In terms of the consequences of that for this case, those are common ground. It's common ground that if you don't ask for consent, the transfer is ineffective. I can't now remember the name of the authority, but it's a decision of Lord Justice Millers. But it does show that the parties contemplated the possibility that there would be a mechanism by which transfers, if justified, could be permitted, namely by consent. And we simply don't accept that there's any difficulty in practical terms with working out whether there would be consent. If you had a contract which contemplated transfer and you got consent to that contract, there would plainly be consent. And to take an example, which I'll come back to later, suppose we weren't dealing with insurance, suppose we were dealing with finance, and somebody said, well, I want to give a security interest in my rights under the contract to my bank, and I want that to be a security interest which will take effect as a transfer to the bank upon an event of default, which would be a perfectly sensible commercial transaction to enter into. You could go to the other party and say, can we have consent to that? There'd be no difficulty. So we've done that. And any such assignment, transfer, or attempt to assign or transfer. So again, broadening slightly still further. Any interest or right hereunder, broadening from rights to interests, shall be null and void without the prior written consent of the other party. Now obviously, nullity and voidness are, in any event, the consequences that English law would attach, but the parties have...
That's what you answered me this morning.
Yes, and I think that's common ground. That is, English law had... it's not obvious that it should be so. American law doesn't, for the most part, reach this conclusion. American law, for the most part, as I understand it, reaches the conclusion under the Uniform Commercial Code that an assignment in breach of an assignment clause is a breach of contract, but an effective assignment. English law does the same thing in relation to some property interests. If I agree not to transfer my land, but I do transfer my land, it may be effective as a transfer, albeit a breach of contract to have done it. But I think that's right, but I'm not a landlord.
I think it's actually quite complicated.
but it's quite complicated. Anyway, at least it is clear that English law took the view, and I don't think it's common ground, that nullity and voidness would attach anyway. But it's not insignificant that the parties have chosen to reinforce that by saying in terms that nullity and voidness is what attaches not only to a transfer, but to an attempt to transfer. And then the second exception, notwithstanding the above and subject to prior notice, the seller shall have the right to enter into subcontracting arrangements with any third party for the purposes of performance of the contract. Now, taking the two exceptions, we've got one exception at the beginning, except that the warranties in Exhibit 4 shall be transferable to the customer. That's, in a sense, a true exception to the transfer of rights. And then this exception, which is dealing with subcontracting, which is interesting because it suggests the breadth the parties attach to the meaning of the word transfer. Because subcontracting would not necessarily be thought of as a transfer at all. But it is clearly thought of as being within the scope of the first part of the clause, because it attracts a not unqualified exception for subcontracting subject to a seller's prior written notice, but not the requirement of consent. So overall, a stringent and broadly drawn prohibition. The focus is clearly not technical. It positively disclaims any interest in why, or how, or by what means, or to what extent a transfer takes place. It has no interest in whether the transfer consists of the true, legal, or even equitable transfer of the contract itself, but it includes both interest and performance obligations within the scope of its prohibition.
It does have to be by a party.
But it does have to be by a party, absolutely. And it's explicit and decisive about the consequences which follow. Now, then I come to set that in the context of the agreement as a whole, and what other clauses might cast any light on the and I'm within the scope of the agreement on the construction. And there are three points to which we draw attention. The first is this, that there is an arbitration agreement. So the parties contemplate a private consensual, in the sense of consensual as in the appointment of the arbitrators, dispute resolution procedure. And that in turn implicates three reasons why parties themselves commonly contemplate prohibitions on transfer as well. The complexity that transfer gives when you have to deal with multiple parties, a complexity which is greater in arbitration, confidentiality, which I will come to later, and a desire to maintain a legal relationships with a particular entity with whom one also has commercial relationships, because that affects the way that disputes get resolved in the real world. We all know that once contractual rights sit in the hands of someone whose only interest is in enforcing those particular rights and not any long-term interest in a commercial relationship, the kaleidoscope sometimes shifts. The second aspect are the confidentiality provisions. Those confidentiality provisions fall to be said in the fact that this is a contract dealing with the export of military or equipment containing militarily, defensively secret, sensitive components. One can see that, for example, by Clause 21, which deals with export control. And there are stringent confidentiality provisions in Clause 20. And as my learned friend rightly pointed out, those cover, first of all, the confidentiality of the contract and its provisions and exhibits. That's Clause 20.1. And they have two exceptions, exceptions only. Disclosures in relation to disclosures that we undertake. That's in 1. There are some limited exceptions. And then in subparagraph 2, with respect to disclosures of technical information undertaken by a party, to the sole extent such disclosures are made by a party to its financial, taxation, or legal outside counsels, which shall be bound by confidential obligations consistent with the provisions of Article 20. You will note conspicuous by their absence, insurers. And then 20.2, which is dealing with confidential information provided under the contract, so that's information about except to the extent specifically authorised by 20.3, which deals with the pre-service maintenance provider and the customer. Except or specifically authorised in writing on a case-by-case basis, the information has got to be protected and kept in strict confidence. It mustn't be used for any purpose other than the purpose of this contract. It mustn't be disclosed, nor caused to be disclosed, whether directly or indirectly, to any third party or persons other than those who have a need to know for performing the contract and for the sole purpose of the contract. And it mustn't be copied, reproduced, or duplicated. So there are stringent and detailed confidentiality provisions in relation to those things.
What do you understand is meant by its financial counsels?
Yes.
In 20.12.
I might have imagined it meant accountants. That's what I had in mind. That it probably means that if you add them together, financial, taxation, and legal outside counsels. My sort of easy translation was to say it was accountants. It may be there would be other people who would fall within the definition of financial advisors, effectively. Yes. Now, all of those provisions note two things. All of those provisions, first of all, make it extremely difficult to see how insurers could ever be told anything about the actual substance of the contract without permission. And secondly, they make it extremely difficult to see how anyone could ever bring a claim under the contract for breach of the contract other than MBA itself, consistently with those confidentiality protections. And as I say, they are confidentiality protections which do not spring simply from perversity. They arise out of the nature of the goods which are being provided. And those considerations fit then with the purpose of the transfer clause.
Sorry, say that.
They fit with the purpose of the transfer clause. If you're going to strictly prohibit the passing on of information to third parties, that is a very good reason why you'd also want to prohibit the transfer of rights to third parties. Now, the second aspect of the contract are those provisions which deal specifically with insurance. My learned friend showed you both of those. One of them relates to they both relate to property insurances. One of them relates specifically to the ferry flight and is for the benefit of both parties. And one of them, I think, relates to some equipment. What there is not is any general provision in the contract requiring or permitting either party to maintain any other kind of insurance. Now then, turning to from the broader context.
So what do we get from that? That there's no general provision in relation to insurance?
It cannot be said that in buying this insurance, or any insurance other than the ferry flight insurance and the supplies insurance, either party was acting, as it were, pursuant to obligations in the contract, or for that matter, pursuant to anything which the contract contemplates.
Your points about the difficulty the confidentiality clause would create in dealing with insurers, that would also apply on the face of it to the ferry flight insurance, wouldn't it?
There are two possible answers to that. One is that if you look at 20.2b, at least the disclosure to the ferry flight insurers would be for the purpose of performing the contract. It's at page 29, I think, of the supplementary. So you can say, well, if in disclosing to an insurer who you're under an obligation to get insurance, there is then a disclosure which is for the purpose of performing the contract.
No, but that's in relation to information provided by the seller under the contract.
Yes.
What you would need to disclose, it seems to me, are details of the contract.
Yes.
And its provisions.
I'm not sure that's necessarily right for the ferry flight insurance, my lord, because the ferry flight insurance is simply a hull insurance on an aircraft.
Wouldn't you have to tell the insurers what was happening and what was being? They would need to see the full specifications of the aircraft.
Well, they would, but those specifications would almost certainly fall under the information provided by the seller under the contract about the aircraft. That's probably what the insurers would need. If that were a problem, then I accept that one would have to imply a term which permitted those insurers to be told. But it doesn't follow that one implies a term which permits any insurers to be told.
What do you say about the argument that insurers under the ferry flight provisions,
yes,
would on the face of it have a right of subrogation, or to be subrogated, or otherwise it's a Japanese policy, assignees in relation to any claims against the sellers?
Well, there are two answers to that. The first is insurers can always waive subrogation rights. They can insure without the subrogation rights. And in the context of a flight where the insurance is intended to benefit both parties, it's likely that one would expect that they would be asked to do at least that. I'm not going to get into the arguments that one may sometimes have when one has co-insured under a contract and whether that actually affects the claims between them. That's a meat for another day. But it would be very odd indeed if there was an insurance which was for the benefit of both parties, that the insurers were reserving the right to sue one of them for some breach in relation to that. Well, can I then turn to the slightly broader commercial context? And I appreciate that one is now beginning to reach the edges of, as it were, what becomes useful for interpretation. I'll try to keep it as succinct and non-controversial as possible. First, positively, the parties are in different jurisdictions. They're in Japan and France, and they are choosing English law and arbitration, presumably as a neutral system of law. It is quite unlikely in those circumstances that they would have had in mind, or wanted to have in mind, the particular niceties of systems such as French law or Japanese law. On the other hand, as I think my lord, the Master of the Rolls, has said from time to time, English law might be a different matter.
Might be.
A different matter. Secondly, positively, the parties to this agreement did have a pre-existing commercial relationship with each other. That is MBA and Dassault. And one can see that from the recitals to the agreement, which my learned friend, I think, showed you, and in particular from recital 2 at page 8, which records the fact that MBA is Dassault's exclusive distributor in Japan as per a distributorship agreement which is there mentioned. So it's not a one-off contract between people who don't have a pre-existing relationship. And that obviously implicates another of the points I already mentioned as to one of the reasons why people care about who they are dealing with. There is a difference between resolving disputes with people who you have a long-term relationship with and resolving disputes with people who one doesn't. Thirdly, I've made this point already, there were, given the nature of the goods, underlying reasons to be concerned about confidentiality in this case. And fourthly, and this is the only point where I think there may be any element of controversy whatsoever, a negative point, there is no evidence that the parties would ever have expected MBA to buy this sort of insurance. It's very specific, odd insurance. It is insurance which specifically covers MBA's risk of delay. Now, if it is said there is a kind of commercial practice which can be relied on by way of factual matrix, everyone would assume that you had that kind of insurance. I do not accept that there is any evidence which would support that. There is, in fact, evidence to the contrary, which is that this insurance was not bought by MBA until 2017. In other words, it is not insurance which they bought at the outset of the contract. It was insurance which they put in place later.
Did they buy it after the delay had occurred?
I'm not sure if the delay had occurred at that stage, but I think
They knew it was going
the
to.
suspicion was that it might have been on the cards. But again, that isn't irrelevant to construction. It's an interesting background fact, but it's irrelevant to construction. What is relevant to construction is that your lordships cannot assume that there would be something very odd about a contract which did not enable that kind of contract, that kind of insurance to be put in place. And that's actually generally true of liability insurance in the context of sale of goods. Liability insurance in the context of sale of goods will often cover damage that you might do to third parties. It very rarely covers damage which is done in the sense of the goods being defective or there being some other contractual breach. But it doesn't matter whether I'm right in saying it very rarely covers it or not. I'm not making the positive point. I'm making the entirely negative point. But there is no background of assumptions about practices that people in this market have about the sort of insurance that they'll cover, which might simply have not slipped into the agreement.
No, but trading companies do get insurance of various kinds.
Yes. So I'm not saying it. That's why I'm not making the point that parties didn't expect it. I'm simply making the point that it cannot be said that the parties did.
Liquidated damages here are 1.7 billion yen.
Something like that.
Do we know what that is in sterling or dollars?
I don't, but I'm sure someone does. Mr. Leslie will tell me in a moment. Now, those are the contractual terms. Now, neutrally, let's have a look at what actually happened in this case.
So this is the second head of your submission.
Well, this is really me coming to apply, because what we have
Yes.
is we have an interpretation problem.
I noted down one interpretation, two applying the words to the
Precisely.
circumstance of the good.
That
It's
is
very dull. My notes are very dull. I'm just relying on what you said.
Your notes are better than mine. It's the sad truth. What happens is that MBA buys in 2017 the insurance policy from MSI, specifically to cover the risks of its potential liability for damages for delay. And it does so under terms of a policy which includes, your lordships look at page 114 of the supplementary bundle. And that's a misreference on my part. Because I was meant to be looking at 4. But it is in the supplementary bundle, and let's stay there. It's at 126. So your lordships were shown, I think, Article 25 of the Japanese statute. Article 35 of the policy, which is headed subrogation, says that in the event that the insured acquires a right to claim for damages or other claim as a result of recurrence losses, such claims shall be transferred to MSAD when MSAD pays the insurance benefits for said losses. However, the amount to be transferred shall be limited to the maximum amount in the following table. Depends on how much of the losses have been paid. And you can see it doesn't quite work the same way, at least I think this is right, it doesn't work quite the same way that English subrogation works, because if there's been a full amount of the losses, then the full amount of the claims is recovered. But in other cases, there's a reduction. And in some cases, claims may continue to be held by the insured without being transferred to the insurer. So there can be both people involved, and those shall be repaid in priority to claims that have been transferred. So the insured rather gets the first bite of the cherry, not quite English law. And the policyholder and the insured shall cooperate in preserving and exercising the claims under 1 and 2 and obtaining evidence and documents for that purpose, and bear the costs required in relation to that. So the contract in fact contains provisions which effectively mirror the provisions of the Japanese Insurance Act. Now, it is common ground between the experts that they need not have done so. There is no requirement under Japanese law that the insured must give subrogation rights to its insurer. The parties would be free, if they wished to do so for the benefit of the insured, to reduce or remove those subrogation rights. But as you can see, they chose not to do so, and they chose, in fact, to incorporate in their contractual document something which is the equivalent of the terms in the Japanese statute. And what the experts, the tribunal ultimately decided, the experts then disagreed on what might seem an entirely theological debate in a sense. Given that there is a contractual term which says subrogation, and there is a legal term which says subrogation, pursuant to what provisions does the subrogation take place? And one of the experts said, well, if you've got a contractual term, it's the contract. And the other expert said, no, if you've got a contractual term which doesn't vary the statutory term, then it's the statute. And the tribunal decided, and we don't challenge, that as a matter of juridical reasoning, it's the statute. But the plain fact is that in this case, there are a succession. It's not just one voluntary decision. It's not just the decision to buy insurance, which is no doubt a matter of choice. It's the decision to do so on terms which not only don't exclude, but indeed positively include provision for subrogation, although they need not have done so. And then down the line making the claim on the policy. And so when one asks the question, well, why is the transfer which takes effect, as Article 35 of the policy says, not a transfer by any party? As I understand it, one has to take it in stages. MSI accepts that if the transfer had taken place pursuant to an express term of the policy, in other words, if that little theological debate between the Japanese experts had gone the other way, that would have been a transfer by a party. That would be no different from the example my learned friend gave of the express assignment pursuant to a subrogation provision in English. So that would be an assignment by a party. And that must surely be the case even though the conditions for that assignment have not yet taken place at the time the party signs it. And I'll come back to the example I gave of the banking document. If I gave my bank a document which said, in the case of an event of default, there will be a transfer of the rights under this contract, and you ask the question, was that transfer by a party? The answer is it would be by a party. No sensible commercial person would think differently. The same would presumably be true if the subrogation rights arose as a matter of implication from the contract. An implied term is, after all, a term. Very difficult to say that a subrogation or a transfer pursuant to an express right in a contract was one made by a party, but an implied one wasn't. And what really matters in both of those cases is that it is by virtue of the contract that the subrogation takes place. And my loan infringement argument really comes down to saying, well, all of that is right, but because, technically speaking, the contract is what gives rise to the right of subrogation. I accept that. Japanese law doesn't give rights of subrogation to people who aren't insurers. It gives rise to people who are insurers, who've entered into contracts. And although you were indeed the master of the extent to which the rights were transferred, you were totally free to agree a contract in any terms you wanted to. And although you did in fact agree a contract in terms which provided for a transfer, by virtue of this entirely arid from a contractual point of view, juridical point, that, well, it's, if you had to draw a diagram which said what affects the transfer, the answer would be the statute, not the contract in and of itself. But that is not a transfer by a party. And my lords, my submission is that that is, as a commercial reading of a commercial contract, not a tenable one. Imagine
It's not what? As a commercial reading?
As a commercial reading of a commercial contract, it is not a tenable construction.
It's not tenable. Why is it not tenable when the words say the transfer must be by a party if it's not by a party?
Because it is by a party. Because
Why?
every commercial person would say, if you said, imagine the debate. If they phone up and they say, you know, hi Jean, we've transferred our rights under this contract. Or the rights under the contract have been transferred. And Jean says, you know, well, hang on a second, clause 16 prohibits that. And you say, well, don't worry. See, we haven't transferred anything. It wasn't done by us. It was done by Japanese law. You say, well, how did that come about? You say, well, we entered into an insurance contract, and that's what the insurance contract says will happen.
I mean, before you start digging into the archaeology of how it came about, you surely ask whether the transfer was by a party or not.
Yes.
And then you have your lovely academic debate as to whether it was under 25 or 35, which is, as it turns out, by sheer fluke or good luck or great experts or whatever, you lost.
Yes.
And you didn't challenge. And
Correct.
so the actual transfer takes place pursuant to Article 25. Now,
and the contract, my lord. I mean, one's asking a question which is almost I'm not trying to delve back into the dim and distant causes.
which contract?
The insurance
contract.
Yes. Article 25 is about the transfer of rights under insurance contracts. It's not. It may be, as it were, an incident of the insurance contract, but I think the question I'm asking is and maybe your lordship's answer will not be the answer I want you to give. Is would commercial people agree in this term really think it made a difference?
Well, what did the judge say?
The judge said it was
you seek to support the judge. Can you
Yes.
just show me how she put this point? Because nobody seems very interested in what the judge said.
Well-
At least I asked Mr. Smith to show me where the judge went wrong, but he was doing so well he didn't think he needed to. So he didn't. But I'd like to see what she said.
well, I'll show you.
I mean, it
fine.
is an appeal against her judgment.
No, quite right.
I know that's eccentric.
Quite right. It is. Well, she deals with the wording of the clause and context and commercial purpose.
So where are you?
Yeah, I'm just trying to find the passage where she actually gets to the.
I mean, basically, under the authorities, she concludes at 64, and then she deals with the wording of the clause
Yes.
and the by issue.
Yes.
I find preferable the submission 72 for Dassault that this wording invites attention to why the assignment happens, in the sense of whether a party chose to cause it to happen.
Yes.
Now, where does that come from?
Well, that was, in a sense, the submission I'm making as to what by means. Did the party do it, or was it done to the party? In other words, by is about agency. I'm not saying it's about causation. By is about who did this. Who did it?
Right. By is about agency, yes.
And so it's not just a question of why it happened, because that's a much broader course of thing. If one asks in commercial terms, who did this transfer? The answer is, it is MBA that did the transfer. And if that would be right, if Japanese law said it's an implied term of an insurance policy that you will have this subrogation, nobody would have any doubt about it.
I mean, I don't see that being the argument you advance below, because in paragraph 70, she says, you said, well, MSI said if the party's action directly and immediately affects the transfer, even if the transfer is not only or solely as a result of the party's acts,
Yes.
focuses on the direct mechanism by which the assignment occurs.
Yes.
And you said whether a considerably lesser or less immediate party involvement suffices.
Yes.
And focuses on the cause. And now you're submitting, are you, that by is about who did it?
Well, I don't think it's cause in that sense. I don't think I'm making an argument which is any different from the argument. In fact, I'm confident that I'm not making an argument which is any different from the argument that I made before the judge, and even in the order that I made it before the judge. The focus was.
Well, you were talking below about hands-on and autopilot.
Yes.
I mean, I found that pretty hard to understand, but I mean.
Well, it was an example which came up in the course of argument. If you imagine somebody's flying a plane and they've got their hands on the wheel, you would definitely say the plane was being flown by them. If you put the plane onto autopilot, you wouldn't necessarily say the plane wasn't being flown by them. They've taken all the decisions about where the plane is going to go. It might be different if it veered off course in some way. But in commercial terms, it's very difficult to see that if turning it round, why would the parties think that the operation of this clause, which is otherwise framed in very broad terms, which evince no interest whatsoever in the mechanism by which a transfer occurs, think that it really makes a difference whether the transfer occurs pursuant to an implied term or pursuant to a rule of law which takes effect unless the parties have agreed to the contrary. It makes.
I mean, don't you think that the argument below got a bit fixated on this voluntary versus involuntary distinction, which came out of that Latin tag I find forgettable?
Invite, yes.
Yes.
It did get fixated on that way. But in a sense, the reason it got fixated on it from that perspective was because the tribunal had focused on this supposed rule that there is a special rule relating to transfers by operation of law. And that's not a useful way of approaching it. The right way of approaching it is simply by asking what this clause means. And
so the tribunal, you say, got fixated on the transfer by operation of law. I mean, my sort of, again, rather brief reading of the tribunal's decision was that the majority basically concluded, having fussed about the nature of subrogation, it said it's well established 159 and says 160, in English law a contractual prohibition will not ordinarily be interpreted as extending to assignments by operation of law.
Yes.
Sort of. And then Professor Good is very interesting on all that. And the conclusion is there's good reason of legal policy why an assignment which is provided shall take place in law, should be prevented or prohibited, certainly without there being a clear manifestation of it. Sorry, Andy.
I read the key reasons being 162 to 163. So in 162 they deal with the cases, the Doe line of cases, and then at 163 we get the answer consequently.
I suppose 180 is the conclusion.
Yes.
The because the transfer was by operation of law, the consent of Dassault wasn't necessary.
Exactly. But the fallacy, or at least what we were submitting, it's not an appeal, of course, but what we were submitting to the judge below, and I submit to you, is the problem is this expression by operation of law is slippery, it slithers. And it starts off in those cases as meaning something which happens because the law imposes that obligation regardless of your action. That's what it, and your will. That's what it in vita means.
Mm.
And it ends up then being used to mean if it operates by some kind of legal mechanism. Now, if one asks the question in this case, if that is the right way of looking at the word by, which it may or may not be, if one asks the question in this case, which side of the line does this fall? It falls on the voluntary side of the line. This happens because in every possible way, MBA brings it about. And not just brings it about by circumstances which it creates, it brings it about by a contract that it enters into, in relation to which that is one of the legal incidents of the contract. And the tribunal's error is to say, well, it really matters whether that legal incident arises pursuant to the contract's terms or pursuant to some law outside the contract. And that's, I'm not saying it's a meaningless question, but it's, in my respectful submission, not a commercially meaningful question. Why would the parties care about that? They might well care about whether this is something which MBA did, which is effectively what by means. And judged by that
the decision that the judge upheld is in paragraph 7 of Mr. Crookenden's opinion, where he says any transfer of rights under the policy would be the consequence of the voluntary decisions of MBI and MSI to enter into the policy.
Exactly.
So it's a sort of one of those wonderful sort of but-for questions.
Well, he's saying, he then goes on to say, any such transfer would therefore itself be voluntary. I understand him to be saying it would be a transfer by MBA because they've decided to do it. And then they've done it.
Well, they didn't decide to do it. They decided to enter into a policy with a particular term under a law that provided for an assignment. They didn't decide to have a delay. They didn't. Then there was a delay. Then there was a claim.
Yes.
I mean, I'm assuming they didn't know there was going to be a claim when they entered into the policy in their favour. And they made a claim in good faith. And the legal consequence of that was that there was an assignment.
Well, I'm not sure your lordship would let me get away with that. If suppose it were a security document,
yeah,
and it had the provision which said there will be an assignment on an event of default, and I said, well, no, I didn't decide to do that because I never hoped that there was going to be an event of default. Your lordship would say, well, that's not the point. You still did it. You entered into the contract which contained those terms.
Let's assume you're right. That's not what this contract says.
Well, it more or less is.
Well, it may say it, but it's not the relevant. It's not the relevant event because it's been found against you that it was Article 25 that gave rise to the assignment, not any agreement made under Article 30.
Well, the event is the same event. It's the payment of the claim pursuant to the policy. You can't put the policy out of the picture for Article 25 because Article 25 exists only if the policy exists and only if the policy contains the terms that it contains. It's therefore, your lordship is right to say that it's been decided against me as a question of law, that if one traced this back to its origins in terms of its kind of DNA, it would have statute in its genes rather than contract in its genes. But actually, you only get those genes as a result of the contract. And my submission is...
The problem I've got,
yes,
Mr. Spencer, maybe it's one of these telescope things, you see it one way through one end and then you change to the other and you see it the other way.
Yes.
The problem I've got is that if you're talking about a transfer or an assignment by a party,
yes,
then I don't see why you go on an archaeological expedition to go back in various stages of causation.
yes,
To see whether something that the party did has ultimately been a cause
yes,
of the a transfer, because normal meaning of words is an assignment by a party is a document entered into under section 136 as a matter of English law, or
Yes.
something else in different laws. Transfer by a party is a transfer by a party. I mean, I give you my aeroplane, here you are, I deliver it to
Yes.
you. It's not really, I set up a set of circumstances to which if I hadn't set up, this transfer wouldn't have happened.
Yes.
Is it? I mean,
Well, thus
what
far,
I'm
I think
asking.
I agree with your lordship.
Mm.
But what I don't accept is that that's what I'm doing.
Right.
What there are two. Your lordship talks about the archaeological investigation, and I like to talk about the theological investigation.
Mm.
The plain commercial fact, if you ask the question, why did this happen? The answer that anyone would give is it's because MBA entered into an insurance contract which provided for it to happen. It's only a lawyer who would say, well, hang on a second. It's not just the contract which provides for it to happen. It's the existence of the Japanese statute which operates in conjunction with the statute, and that's what brings it about. But that isn't in commercial terms, that is not a more useful investigation. It's a highly problematic investigation, because it's an investigation into something which is maybe a totally unanswerable question. Go back to the simple example your lordship gave me of the Law of Property Act assignment. And you say, well, how does that operate? And the answer is it operates under section 136 of the Law of Property Act. And if you said, well, is that a transfer by a party? We would all say, yes, it absolutely is. But if we said, is it just a transfer by a party? We would say no. We'd say no transfers are ever just transfers by a party. There is always a legal provision which affects the transfer pursuant to the party's will. Intangible rights simply can't be handed over like playing cards. They require some kind of legal substructure to do them. And if one asks the question, what is the Japanese statute in this case really adding? It's adding nothing more than that. It's adding nothing more than providing a juridical basis for a transfer which the parties have agreed should take place. And that is, in my submission, a transfer by a party. That's the only point about the Law of Property Act. It's not, and that's why this slip, this slippage in this reference to operation by operation of law is such a dangerous slip, because it confuses two quite different things. One is where the law comes in from outside and says, we're not interested in what you want to happen. We're just going to impose a transfer. Classic example would be the 1930 third-party rights against insurers. Now that's plainly a transfer which could not be described as a transfer by a party. But if what happens is you have a legal substructure which gives effect to an agreement that the parties have entered into, which provides for the transfer, then in my submission, that is a transfer by a party. And that doesn't involve an archaeological investigation of the background history of it. That just is what it is.
You plainly could have a legal substructure which undoubtedly and expressly provided for a transfer by a third party.
You could not.
So the fact that you've been party to the legal substructure doesn't necessarily mean that any transfer thereunder is formed by the party who enters into that.
No, I agree with that, my lord. It's certainly, I can't say that every time there's a legal substructure, there's a transfer by a party. That's obviously not right. What I say is that there are no transfers which take place without a legal substructure. Transfers of intangible rights can happen and happen only with a legal substructure. And so when one is asking what is a transfer by a party, it will not help you to ask, does this happen by the party in its own unaided form with no kind of legal support?
Don't we have to look at this a bit more broadly? And this is an English law contract.
Yes.
Which is which must be looked through an English law lens. And through that end of the telescope, a policy of insurance which gives rise to a right of subrogation on the part of an insurer would not be seen as an assignment by a party to the insurer.
I'm going to come to that in lots more detail.
Yes.
But can I give you a short answer?
Well, I haven't asked the question.
Sorry. Sorry.
But if you know what the question is, then
No, I don't.
But the point is that, of course, we're focusing on the word by, but in the overall context of this clause, the fact that there is a Japanese law which provides for a transfer by way of assignment, should that be read, therefore, as being a transfer by, even if you're right on your analysis, by the insured, rather than, as is generally viewed, the rights of subrogation arising by operation of law without a voluntary act?
Yeah, no, I understand the point. My short answer is yes, because I don't accept your lordship's first premise. I don't say that necessarily subrogation would be a transfer by a party, but that's not because it's not by a party, it's because it's not a transfer. If it's a transfer, it is a transfer by a party. And that is actually, as a matter of English law, pretty clear, because subrogation in an insurance context does not operate by operation of law. It operates pursuant to an implied term in insurance.
That's my point, is that in context of this type of clause, looking at it from an English law perspective, you would not expect the right of an insurer to sue, albeit by way of subrogation, to be caught by this clause. So why should it catch a different legal formulation of that right, which is a pure technicality?
I understand the point. I still think I've challenged the premise. It properly construed, when one understands why the clause exists, and one says, would the parties have wanted an insurer to come in, have all the how is the insurer to run this case, even in a subrogation? How can that happen without them being given all of the information, all of this confidential information, which is confidential to the parties? Nothing in the contract which permits that to be done. How can one? Is it surprising at all in that context that the parties would have said no? If you want to have your insurers sticking their nose into this relationship, you will need our consent to that. Because where are the insurers from?
How would they do it? How would they do it by way of subrogation?
Well, that might be a question as to whether they could do it by way of subrogation. In other words, what I'm accepting is I'm saying it's not obvious, my lord, that subrogation would not be caught by the clause. Not at all obvious.
It's not obvious that it would not. How many negatives do we have? 2. So it is obvious that it is.
No.
No.
It's unclear whether it would be or wouldn't be.
Right, that would be an easier one.
And the reason it's unclear is because although it is absolutely right that it's very difficult to see how you could operate subrogation consistently with clause 20, very hard to see.
Well, how did the insurers in this case plead their request for arbitration?
Well, there's been debate in the tribunal about that and the extent to which they can use confidentiality. I don't know the answer to that, and I don't think it matters to the construction. But there is an ongoing issue about it.
Ongoing issue about what?
About confidentiality of these documents in the context of the arbitration.
Oh, right.
Well, they're in open court now.
Well, that's true. These documents, at least, are now in the public domain. And that might be, in some circumstances, very important because it would depend on the nature of the case, whether, for example, the technical details about the aircraft and its equipment really matter. Anyway, I'm sorry. I realise that that's only half an answer to my Lord's question, but I'm going to come to subrogation later anyway. I think I've probably exhausted what I had to say about the application. Can I deal with the...
I'm a little terrified by the later business, it being now 3 o'clock
I appreciate
and you needing to give some time
and I will.
reply. Yes.
I will. Can I deal with the English cases and deal with those quite rapidly? In my submission, they're just not helpful. They're all dealing with different wording.
Well, nobody says they're helpful in that sense. All that is said about the English cases is they demonstrate that there is something which can happen by operation of law as opposed to by the operation of a party, and that
Yes.
may have different consequences.
That's all they demonstrate.
Yeah.
But in a sense, we knew that in those cases, you might have said, well, we don't know that because we don't have the word by a party in any of those cases. None of the cases is dealing with that. They were dealing with, well, what's the meaning of a sign and all of those things. So none of them is actually dealing with that. The one authority, or the one of them that I in any way quibble with my learned friend's analysis of, and again, I'm not sure it's actually going to help you very much, is Cohen, where my learned friend is right in what he says, I think, but is missing the kind of background history at the time. My learned friend is right.
Do you want us to turn that up?
Yes, please, my lord. It's tab 5 on the authorities button. I think my learned friend's point was, well, those authorities can't apply where you're dealing with a liquidator, because a liquidator acts on behalf of the company anyway, and therefore an assignment by a liquidator is an assignment by a company, so the issue simply doesn't arise. Now, that is correct, and it was so decided by the Court of Appeal in Re Farrow's Bank, which was a compulsory liquidation case. At the time that Cohen was decided, however, it was, I think, thought as a result of the decision in Re Birkbeck, where it had been suggested obiter that might not be the case, and that's explained in Farrow, that that wouldn't be so. And it's in that context that Mr. Justice Rowlatt in Cohen was drawing a distinction between voluntary liquidation and adjudication, because voluntary liquidation was effectively, he uses the expression, tinged with the taint of voluntariness.
So a distinction between voluntary liquidation
and adjudication, bankruptcy adjudication.
Which was equivalent to compulsory winding up.
Yes. So, to that extent, it's, I mean, I'm not saying it necessarily helps you one way or another, but the expression that the judge uses, the tinged with the taint of voluntariness, was done in the context that
So which page is that on?
That's on page 50 of the bundle.
the highlighted passage we looked at this
Exactly.
morning. Yeah.
Well, the only other of those cases that my learned friend took you to, which I would in any way say anything about, was the decision in Thomas and the National Farmers Union. Bear in mind, that's a case where the judge is actually interpreting the word by operation of law. It appears in the clause in the policy. It wasn't a question about whether it was voluntary or not, or an assignment. It was about whether a policy had ceased to apply when the policy's term said it would cease to apply if the transfer was by operation of law. And so it's the danger of taking a 1961 decision, and then using that to interpret words used by a judge in 1815. I mean,
even by Mr. Justice Diplock.
Even by Mr. Justice.
But isn't the point against you that it's recognised in the authorities that operation of law may take a transfer or assignment outside of these clauses? And here we have an express wording which requires by a party, which is in complete contradistinction between operation of law.
Well,
so where you have, as the authorities recognise, these assignments by operation of law, they are not, it is said against you, by a party. And that, as I understand, is the thrust of the argument based on these authorities.
yes, but the difficulty with that argument is it simply takes one to the same questions to determine what this was. The important thing to understand is that when those authorities use the expression by operation of law, what they mean in every case is without the voluntary action of the assignor. Now, they support my Lord the Master of the Rolls view that one doesn't engage in a long causal analysis as to how the overall situation was brought about, and one focuses on the particular transaction by which the assignment takes place. But that's not a problem for the guy who perfectly accept that. What they don't do is say, well, if it's pursuant to a statute, it's not by operation of law. That's not what operation of law means in those cases. All of those are cases where you're looking at a sheriff's execution in the first of the case. You're looking at an order of the chancellor in the Lambeth pub case. You're looking at adjudications of bankruptcy in other of the cases. They're all cases where something has been done, which the insured has no, the transferor has no say in whatsoever. And the difference with Cohen is that Cohen was drawing the distinction, saying, well, hang on a second, this voluntary liquidation doesn't look like any of those. This is something which they're doing. And therefore it is binding. Now, subject to that, that was all I wanted to say about those cases, because interesting, fascinating as they are, pieces of legal history, they don't otherwise take the debate any further. In one sense, I might say this: your lordships don't need to be told here that you are looking for something which is done by a party, because that is what the clause says. The difficulty is what that means, and the cases don't help you on that point. In the same way, in my submission, the fact that a textbook draws a distinction between voluntary and involuntary assignments is not going to help you to answer what the word by means. And nor, if I can
even a textbook written by your junior.
It's very useful for many purposes, but not for this one. Nor will the Rome regulation. I only want to spend a very short time on the Rome regulation, if I may. That's at 167 in the authority.
It doesn't seem to. I mean, I'm not sure the Rome regulation.
Well, the problem is, how can it
be a long way from what we're talking about?
How can you interpret a contract by reference to a conflicts of laws instrument? It would be a very bizarre construction of a contract, especially when the conflicts of laws instrument doesn't even say anything like by a party or voluntary. It's not looking at them. And although it's true that commentators have discerned a difference between Article 14, which deals with voluntary assignment and contractual subrogation, and Article 15, which deals with legal subrogation, Article 15 certainly doesn't cover the ground as far as legal subrogation is concerned. Wouldn't apply here, for example. If one substitutes, one has to put a towel around one's head to do it, I'm afraid. But if one substitutes the relevant words, where a person, the creditor, so that's MBA in this case, has a contractual claim against another, the debtor, and that's a Dassault in this case, and a third person has a duty to satisfy the creditor, or has in fact satisfied the creditor in discharge of that duty, the law which governs the third person's duty to satisfy the creditor shall determine whether and to what extent the third person is entitled to exercise against the debtor the rights which the creditor had against the debtor. It's dealing with suretyship.
Wet towels are needed all round.
But the point is here, MSI has not satisfied the contractual claim which MBA had against Dassault. It hasn't done that. It satisfied a claim which third parties had against MBA. And we're just entirely outside Article 15. But the bigger point is you can't interpret this contract by reference to the Rome regulation. So then can I come finally, conscious of the time, to subrogation?
So you say your basic submission is not a positive one.
No.
You say you don't know.
I don't know whether subrogation would be a transfer. But I do know that if it is a transfer, it would be a transfer by a party. That's my submission. So if it falls outside this clause, it does say because it's not a transfer, not because it's not a transfer by a party. Now, as to whether it's a transfer, subrogation famously comes from the indemnity principle in insurance law. And it's got a number of different outworkings. The first point is that it means that under English law, if the insured recovers from a third party money which the insurer has already paid, then they are under an obligation to pay that money over to the insurer. And the second principle is that English law permits the insurer to bring claims in the name of the insured. Now, English law does not transfer those claims to the insurer. The insurer has no rights to bring a claim in its own name, and the insured remains able to give good discharge, and no one else is able to give good discharge. I suppose the insurer can do it in the name of the insured, but it's the insured that gives the discharge.
Well, if you say all that, then you're saying it's not a transfer.
Well, and here's the only reason why that doesn't look like a transfer. At least that's.
No.
But the only respect in which it might be said that it looks like a transfer is that there is authority. And we provide it electronically. There is House of Lords authority that when an insured receives money, they will hold it on an equitable lien for the insurer. That's Napier and Ettrick. And in that case, Lord Templeman described them as having an interest in it.
Sorry, what was the name of the case?
Napier and Ettrick against Hunter. My Lord, we can provide a physical copy. I wasn't going to...
It's Lord Napier.
Lord Napier and Ettrick.
Lord Napier, that's a great case, yes.
It was the Lloyd's names.
Yes.
In fact, one of them wasn't him, as it turned out. That was and the question was, did the solicitors had received the payment from the negligence action, and the question was, could they pay that straight over to the names, or did they have to hold it? And the answer was they had to hold it on an equitable lien. The equitable lien being justified on the basis that there was that equity would enforce by injunction the right, effectively not.
But how does that indicate there was a transfer?
Well, I'm not sure it does, my lord, but it provides at least a proprietary interest in the proceeds once received. What the House of Lords declined to do in that case was to answer what was the position about the shows in action before the proceeds were received. Because
Where is Napier?
Did we send it electronically this morning? We did. Because I saw it yesterday in something that Lord Hoffman said in Financiera.
It's not in the bundle.
No, I can provide you with a hard copy if you'd like to see it.
Don't do hard copies.
No, I thought you didn't, which is why I asked for it to be sent electronically
I'll
to my
find
lords.
a soft.
Did we send it?
Do you have a reference within Napier?
Yes, two references, my lord. The first is at page 736.
736.
Yes, in Lord Templeman's speech. Between C and E.
Hang on. Seven 736.
736, my lord, yes.
C and E.
Yes.
Contractual promises may create equitable interest.
Precisely.
Express promise by a vendor to convey land Promises implied in a contract of insurance with regard to rights of action vested in the insured person for the recovery of an insured loss from a third party responsible for the loss confer on the insurer an equitable interest in those rights of action to the extent necessary to recoup the insurer who has indemnified the insured person against the insured loss.
Yes.
Yes, I remember.
And it's at 7. I don't think my Lord needs to turn up. It's at 745 that Lord Gough explains why they wouldn't decide what the position was on the chosen action before that point in time. And there's a very similar explanation given by Lord Brown Wilkinson as to the basis for the equitable lien, namely that it arises out of the enforceability, as he puts it, the specific enforceability of the contractual promises. And I thought I'd marked that. At page 752. Now, my Lord, what the significance for present purposes, they say, well, that's why it may be that it may not be that a subrogation actually is a transfer at all, because if the only right that the insurer has is a right in the an equitable lien over the proceeds when received, then there's nothing transferred. Nothing under the contract is transferred at all.
And I would have thought that was obvious. It's only an equitable lien.
Yes.
Transfer.
Yeah. But if there were a transfer, then it would be a transfer by a party. And the reason I say that is if one asks what is the basis for subrogation in English law, the answer is it is implied terms in the insurance policy. And you saw that in what Lord Templeman just said. The classic statement of it is Mr. Justice Diplock in Yorkshire Insurance.
Sorry, can you just say that again? What's the classic? What did you say?
I said that
if there were a transfer, it would be a transfer by
a party.
By a party. Why?
Because it is a transfer which takes place because of an implied term in the insurance contract.
Oh, yeah.
And as I say, the classic authority or the classic statement of that is Mr. Justice Diplock, as he then was, in Yorkshire Insurance. The relevant passage is at page 94 of the authorities bundle.
So that explains your opening submission on this part, which was you don't know whether subrogation would be a transfer, but you do know, you say, that it would, if it was a transfer by a party.
Exactly. And
but I think you've now really submitted that subrogation is not a transfer.
Well, if the furthest it goes is Napier and Ettrick, then what it looks like is simply contractual rights between insurer and insured.
Indeed.
And that isn't a transfer.
Yes.
Yes. And it would be, I can see someone might argue, well, in this case, transfer was intended to be much broader than that and all of those things. That would only matter here if it was going to help your lordships to decide the issue that you actually have to decide, which is whether something which undoubtedly was a transfer, and everyone accepts was a transfer,
I'm
was a transfer by a party.
Suggest that if you don't know, Mr. Spencer, whether subrogation is a transfer or not, and you think it's not, and you've had a lot of time to prepare for this
Then
case,
it probably isn't.
It probably isn't. A bit like an elephant.
I'm not fighting that.
You're not fighting the
No.
elephant. Good. Okay, so subrogation is very interesting, but not a transfer.
Not a transfer, but what it is something which is done by a party, because it's done pursuant to the implied terms in the contract. It's not actually an involuntary transfer, it's a voluntary transfer.
Well, it's not a transfer at all, so.
Well, exactly. Not an involuntary act, it's a voluntary act. And that's a difference. There is, famously with subrogation, some subrogation is a remedy for unjust enrichment, but not so insurance subrogation. It stands on its own.
It would be a voluntary act if it were an act, but it's not an act.
Well, it's an act, but it's not a transfer.
Well, you say entering the policy is the act.
Yes.
Yeah.
If you ask who does the subrogation, the answer is it's the insured that does the subrogation by entering into a policy which contains a term which says, I will be subrogated. And the fact that term is implied can't make any difference at all. Anyway, I was going to give your lordship the reference to that. That's at page 359 in Mr. Justice Diplock's decision in Yorkshire Insurance.
Sorry, page 359.
359 of the authorities bundle. Sorry, page 94 of the authorities bundle.
Page 340 of the report.
So page 339 to 340 of the report, yes. It just begins over the previous page, where he says the expression in relation to a contract is thus no more than a convenient way of referring to those terms which are to be implied in the contract between the assured and the insurer, to give business efficacy to an agreement whereby the assured, in the case of a loss against which the policy has been made, shall be fully indemnified and never more than fully indemnified. Two consequences flow from that. Subrogation is concerned solely with mutual rights and liabilities of the parties to the contract of insurance, confers no rights and imposes no liabilities upon third parties or strangers to the contract. Thus, the insurer who has paid a loss no direct rights or remedies against anyone other than the insured, cannot sue parties in his own name and so forth. And it was that passage which the House of Lords in Napier and Ettrick then said, well, that's right, but it's not quite right, because there are consequences, equitable consequences, which flow in terms of an equitable lien, which could, of course, bind a third party, but they flow from the implied contractual. So if subrogation probably not a transfer, but if it were a transfer, it would be a transfer by a party.
But if it's not a transfer, you accept that it is not caught by the non-assignment clause in Article 15.
Correct, it's not.
So we therefore have claims by insurers, albeit brought in the name of the contracting party, which are not prevented, but by virtue of the technicality of the situation here, the claim which has been assigned is caught. That raises 2 points. One is, why does that make any commercial sense? Yes. And secondly, doesn't that undermine an awful lot of what you said about why an assignment doesn't work commercially for the parties, given the confidentiality, etc.?
The answer to the first point is it flows from the party's decision to use the word transfer as well as by a party. But if it's not a transfer, it's not a transfer. Now, I understand, my lord. It might be, if I were facing an English subrogation, I might very well want to say, well, it's not technically a transfer, but it should be regarded as a transfer within the scope of the policy. Because after all, if it had been done by way of assignment, it plainly would have been a transfer, and therefore it should make no difference that it's been done by way of a subrogation. I can see the argument for making the two, applying the same logic to both, but actually, which way does that lead you to jump? Which I think is the only reason why I'm hesitating at all in just giving a totally straightforward answer to my Lord the Master of the Rolls question. But what it can't do is shed any light on by a party. That's got nothing to do with it at all. I suppose the short answer is, well, if the parties have agreed that transfers are prohibited, but things that aren't transfers are not prohibited, well, there we are. In the same way with the anti-assignment clauses, sometimes they have caught declarations of trust, and sometimes they haven't caught declarations of trust. And there you are, you apply the language. That's a perfectly respectable answer. On the commercial side, subrogation wouldn't, in my submission, be quite as bad as outright assignment, because you will always, at least with subrogation, have the real party with whom you are in fact in contracted relationships there in the room. They may be there in the room through an agent, but they are there. And obviously, it's open to the insurers to say, well, if this gives us problems, we will require our insured to bring the claim. That can be done. That would be an aspect of the mutual obligations between the parties. It's quite different. It's even worse if you hand over to a third party, because you hand over to the insurer. What can the insurer then do? The insurer can then assign to anyone. They're not a party. So they can go off and transfer the rights that they've acquired by subrogation. They can transfer them to a vulture fund, to a Chinese arms manufacturer. There is real merit in keeping the cause of action to the person with whom one contracted. And although I accept that an outright prohibition on English law subrogation would do so even more, it doesn't follow that assignment isn't different. It is. And the third point on this is really, well, suppose that were so, and one thought, well, this looks odd. One still has to find an intellectually respectable way of building taking that perception and interpreting the clause in a way which arrives at the answer that you've decided it should be giving, in a sense. And I don't mean that pejoratively. But in this case, the clause is resistant to that kind of, well, if one goes back to the clause and says, well, what words shall we construe to permit transfer to insurers in this clause? If it's not by a party, which it's not, where are the words which are going to take insurers out of the clause? Well, certainly not the words to any third party. It doesn't say to any third party except insurers. And to imply a term that would say, but you can transfer to insurers, would be to fly in the face of that contractual. Well, what about for the reason? This doesn't cover subrogations. Well, no, because the clause says for any reason whatsoever. So the clause is quite clear that if there is a transfer, with its carefully built-in exceptions, and its otherwise totally comprehensive language, there is no way of saying that because subrogation wouldn't be covered because it's not a transfer, other forms of transfer to insurers are being carved out of this clause. There is not a way which respects the language of the clause which achieves that result.
If the law said, Article 25 said, under this law, on payment of a claim, the party will transfer the claim to the insurer.
Yes. Pose an obligation to do so.
Well, or does it matter?
Well,
would it be different? Is the question I was going to ask. Because if we actually look at Article 25,
yes,
what it actually says is that something shall happen by operation of law.
yes,
Be subrogated with regard to any claim acquired by the insured due to the occurrence of any damages arising from an insured event.
yes,
So the mechanism is actually a mechanism that provides for something to happen by operation of law.
yes.
It does not provide for the party to make a transfer.
It provides that it happens automatically. That's what by operation of law means in this context, yes.
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 So, I mean, it's sort of, I can see how you try and fit it into the clause, but the clause is just not quite competent to meet it.
Well, no, I simply fit it into the clause on the basis that how is by asking the question, how is that different from English law? Suppose subrogations were a transfer. Suppose the position was it was straightforward, the insurer could sue in the name of the insured. And suppose you said, well, there's an implied term in the contract that the insured will assign, thereby creating an equitable assignment which will take place immediately, nothing more needed to be done, as soon as there's a payment. It would be exactly the same, achieve exactly the same result. Operation of law here means automatically. It means without any further action needing to be taken. Now, so I come back to my basic solution, which is the basic difficulty that your lordships confront. Really, the question here is whether you can actually say that when that effect is created, not just by this section, but by this section operating in conjunction with the fact that there has been an insurance contract, and the fact that that insurance contract contains something which permits the subrogation to take place. The fact that it happens without any further formal acts taking place, that's all it means. Does that actually make a difference at all? And if your lordships think it does, then this is not a transfer by a party. And if your lordships say, no, it doesn't, that can't be what commercial parties who are interested in the end result would have been concerned with. This doesn't look like the sort of transfers, third-party rights act transfers or compulsory transfers. You might say, well, that's not a transfer by a party. That was a transfer by the High Court, or a transfer by Act of Parliament. That's the question.
I mean, don't commercial parties want certainty?
Well, but if certainty, they do, we always say they do, but if certainty turns on the translation of the word by operation of law in a Japanese insurance law, that isn't certainty. That is what parties want in terms of certainty is predictability about the outcome. And in my submission, that supports our case.
What I find difficult, I think I've said it before, but what I find difficult is the concept that transfer by a party means transfer happening by operation of law, can include transfer happening by operation of law as a result of something set up by the parties.
I see that, but my lord, I think I'm going to end up simply repeating myself. But
I know, I think we're both repeating ourselves.
The part, in my submission, what one would then say is I'm trying to look at it in entirely commercial terms. And in my submission, in commercial terms, when Jean and Kenji were having their discussion about what had happened, a commercial person would say, look, I'm not interested in how you translate Article 25 of the Japanese law. What I see here is that you have agreed with this insurer to transfer the rights, and that is why they've been transferred. Now, that is a completely accurate commercial description of what has happened. It's not just you engineered a situation in which this happened. You agreed with the insurer to hand over these rights to the insurer. And Jean would say, if that is not a transfer, what is a transfer? By you. No one else did it, you did it. And if that's not called, then effectively no executory contract is going to be called. And the legal mechanism by which that then takes place, and whether it is automatic or requires some further action to be done by MBA, that's of no commercial interest whatsoever. And the right certainty to look for, certainty that a commercial person looking at would be to say that the distinction, I understand that there might be situations in which you have nothing to do with this. And maybe there are grey areas where we might argue about it, but this case is bang slap in the middle of not in the penumbra of uncertainty, but in the umbra. It is certain. You agreed with this insurer that they would have rights, and that's why they are now coming knocking on my door with a request for arbitration. That should not have happened. And that, in my submission, is the correct commercial reading of this contract. Well, unless I can help with anything else, those are my submissions. I don't know. I'm being passed a note. Oh, yes. I was asked to translate yen into the dollars and failed to do so. I'm told that at today's rates, it's about $11.7 million, and in the request for arbitration, it's $16.2 million.
Can I just ask you the policy of insurance we have at tab 3 of the supplemental bundle?
Yes, my lord.
Seems to be by somebody called MS Ampersand AD. Who's that?
Now, I don't. It is. I think. That is the policy, and I can't remember.
Mitsui,
why
Sumitomo,
MSD.
and AD.
Yeah.
Perhaps.
And it's a funny document because it's actually lots of documents and some emails.
And where is, do we have the policy schedule? It's like the very last
The effective coverage clause. I had it just before the short adjournment, and I've now lost my notes where it was.
It's quite difficult to work out.
Yes, I think that's about right. We go to 176, my lord.
I think that's the equivalent of the schedule.
Yeah, the closest that we come.
176.
And you sort of see the nearest we come to an insuring clause is then really at 178, where you'll see there's a heading liability insurance general purpose, and it says covered by insurance costs borne by the insured that arise due to a delay in the delivery of the jets. Yeah, and then the reason given in the bottom of that clause also explains exactly what's been covered.
Hasn't been blanked out.
Sorry?
It hasn't been blanked out.
No.
Thank you. Thank you, Mr. Spencer. Yes.
My lords, just going back to the beginning of my letter from Mr. Stanley's submissions and the question of whether there could be a potential windfall if you are against me and accept Dassault's construction of Article 15. To be clear, we accept that a windfall, the sort that perhaps Lord Justice Phillips was mooting, is not inevitable. Doesn't inevitably follow if you are against me that Dassault are going to get away in one sense scot-free if they're liable. But it is still a potential problem, and it is a potential problem that needs to be taken account of in your decision. MBA has been fully indemnified by MSI. It therefore, as an independent party, has no interest in initiating or pursuing proceedings against Dassault. Now, it is a moot and unknown point whether or not, as a matter of Japanese law, it can be coerced by MSI to bring proceedings against Dassault. And there must be a significant question mark over that in circumstances where Japanese law provides for an assignment of rights. And as my Lord Justice Coulson pointed out, as pleaded at least in the request for arbitration, it said that MBA has lost all of its rights of recourse. Now, and equally under a civil law system, it must be questionable whether or not MSI could have reference to an equivalent to equitable rights of subrogation so as to force MBA to bring a claim. So we do not say, because we do not know, that it is in fact inevitable that there will be a windfall, but nonetheless there are real difficulties in circumstances where MBA, the party who Dassault says can bring a claim, is fully indemnified, has no interest in doing so, and can't necessarily be coerced. And when he very briefly touched on the notion of consent in the context of Article 15, my learned friend made the point that say, well, yes, they could seek consent. They could seek consent to that contract, to the contract of insurance. And again, that just goes back to the point that that's not what Article 15 says. It says consent to assignment, but suddenly it's now being broadened, saying I need to seek consent for an insurance policy. And we would suggest that that is goes beyond the wording of that provision. Confidentiality. Yes, it is correct that insurers are not mentioned in Article 20, but, and again, I think this is picking up a point that my Lord Justice Phillips said, well, how's that going to work then in the context of the ferry flight insurance? And my owner friend first tried to say, well, perhaps any such claim would fall under Article 20.2, and therefore you could say that the insurance was necessary in that circumstances. But again, the answer to it, given by my Lord Justice Phillips, was that you'd need reference to the contract, find out the value of the hulls. My learned friend said, well, no, you could get that information elsewhere, but the contract includes the specification in it. The contract has at the back of it, as a part of it, the specification. And that is surely what any insurer would need to see for these purposes. And so it was as a result of this, my learned friend was thrown back on saying, well, maybe there'd have to be an implied term in Article 20 so as to allow an insurer, the ferry flight insurer, to basically be able to do its job and provide the insurance. But once my learned friend's having to say, well, there has to be, for his argument to work, an implied term in Article 20, we say that that indicates that there's a real problem with his argument, and it instead indicates that insurers are not meant to be caught by Article 20 at all. And there is nothing necessarily difficult about this. Both Articles 15 and 20 are silent as regard insurers. If, my lords, you decide that insurers fall outside Article 15, then why not also outside Article 20? There is really no difficulty there. Another suggestion put by my learned friend in this regard is that, well, the insurer could be asked or required to waive its subrogation rights so that this will work. But if that was right, then surely Article 25, would, the ferry flight insurance provision would say that it's a term of any insurer that they waive their subrogation rights. So we would suggest that that's not an answer. The next point made by my learned friend was that it was never expected by Dassault that this kind of insurance would have been taken out by MBA. Now, to which we say, well, maybe, that may be right, but it doesn't matter, because Dassault's argument applies to all kinds of insurance, even the kinds of insurance that the parties were required to take out, or perhaps would more ordinarily have been expected to take out. And as a result, for its argument to work, it must fit in with all of those kinds of insurance, not just this particular contract of insurance, which maybe the parties might not have anticipated. Now, my other friend made a very technical point by reference to Article 35 of the insurance policy, and it was almost suggesting in one sense that there but for the grace of God went MSI in terms of having its rights under Article 25 of the Insurance Law Act rather than Article 35 of the contract, and if events had turned out just slightly differently, well then the result would be different under Article 15, and thus I think it's being said that it's my client who's almost looking for an arbitrary result and trying to avoid what would be the position under a contractual analysis. But it's important to note what the role is of Article 35 of the insurance policy. And if I could just show you one paragraph of the award in this regard. It's in the supplemental bundle, tab E1, page 298.
Can you just give me that page number again?
Yes, it's supplementary E1 298.
Thank you.
And it's paragraph 176 of the award. And the point that's made here is that Article 35 is actually not intended in many ways to have any standalone existence, but there was evidence from Mr. Noma that was not contradicted by Dassault's expert that Article 35 was actually designed to replicate Article 25 of the Insurance Act, and the purpose for that, you can see in the last three lines, is to draw attention to the effect of Article 25 of the Insurance Act, so that policyholders and insured persons should be specified clearly and simply for them in the general policy conditions. So it's not a serendipity or just a lucky coincidence for my client that we got home on Article 25. Article 35 is only there to draw up in flashing lights to a party such as MBA what the effect of Article 25 is. It's to draw attention to Article 25. But Article 25 of the Insurance Act is the preeminent provision, and it's the one that's intended to take effect. But in any event, dealing with my learned friend's point, he says, well, if this had been an assignment under Article 35 of the insurance policy, it would be by a party and hence prohibited. Which we say, well, even if you agree with him on that, that means that the Article 35 contractual assignment is struck down by Article 15. What's left in its place? The Article 25 of the insurance law assignment. That then, having been struck down, springs up to take effect. And in those circumstances, if that is an assignment by operation of law falling outside of Article 15, there is no problem. One point that was made by my Lord the Master of the Rolls during my learned friend's submission, and it's a very fair observation on mine, when the point was made, where did the judge go wrong? And that was something I never returned to in my submissions. We would be, just very briefly on this. Firstly, we say the learned judge adopted a much too narrow construction of the word by, as seen by paragraphs 72 and 78 of her judgment. And indeed, it introduced into that a causal effect when she says in paragraph 78 she prefers Dassault's construction. That was a construction that my Lord the Master of the Rolls referred to Mr. Stanley, where the reference to cause. Mr. Stanley was being asked whether or not he was now almost disclaiming that and referring to agency. So we say that by introducing that concept of causation into by, it doesn't give the word its ordinary meaning. Secondly, we say that the judge had the wrong reading of the English authorities and didn't focus on the fact that they were all of the cases where there was a transfer by statute, that was a transfer by operation of law, that was a transfer that fell outside the contractual prohibitions, and in none of the cases was there any investigation of the facts leading up to the occurrence of the statutory transfer. And then finally, and perhaps on account of those two errors that we respectfully suggest exist there, the learned judge then did not give enough weight to the point about subrogation being acceptable, and therefore why should this make any difference? And my learned friend in that last point has made a point in his submissions, which I'll come to deal with in a second. When considering the position, my learned friend posed the question, so well, a commercial man would ask, well, why did this happen? And they would say, well, it was because of the policy. But the contract, Article 15, doesn't frame the test in that way. It takes two legal concepts, assignment and transfers, and says that assignments and transfers by a party of court. And therefore, asking, well, why did this happen? That poses the question that he wants to pose, or rather the construction of the clause that he wants to pose on it, but it begs the question. And we say that if you're asking, taking technical terms, an assignment of a right, a transfer right, and asking, have they happened by any party, that necessitates a focus on the mechanism of transfer, not on the question of, it's a question of how, not why, we say it. On the authorities, I made the point in terms of what I say about the judges dealing with them, that the judge should have taken account of the fact that in none of the authorities there is an instance of the court taking a statutory assignment and seeking to characterise it as voluntary. And I say this also about my learned friends' analysis of the authorities. And in Cohen, I've shown you the passages, and it's in Riggs is the key point. Adjudication involved a transfer occurring, an actual transfer occurring away from the bankrupt party to the assignee or the trustee in bankruptcy by operation of law. Whereas in the liquidation cases, such as Cohen and Farrow, there is no transfer by operation of law, and that's the distinction between the two cases, and that's why Cohen does not help the learned friend. Rome 1. I am not suggesting that a conflicts of law tool is a direct aid to construction of this contract. I'm just using the Rome 1 regulation to show the existence of the categorization I rely on as regards species of assignments or transfer, voluntary and involuntary, and has also shown that subrogation is regarded as a species of involuntary or legal transfer. And my simple point is, if subrogation is an involuntary or legal transfer, then why should not disassignment also be the same? Moving on to whether this is a transfer or not. Dassault Aviation are saying that it is not a transfer, and there was a bit of time spent on kind of explaining this, but to a certain extent we say that this misses the wood from the trees. The point is not necessarily whether subrogation is a transfer or not, but it's the point that subrogation is accepted as being not caught by Article 15. Malone and Friends not suggesting that it is caught by Article 15. He says that that's because it's not a transfer. Fine, so be it. But if subrogation isn't caught by Article 15, then why should an assignment to an insurer by operation of law be different? My Lord Justice Phillips said it is just simply a different formula for the exact same result. And when pressed to explain why there might be a difference in practice or a reason why someone in Dassault's position might be happy with subrogation but not assignment, he said, well, with a subrogation you get the real party there in the room, but then qualify that, well, in the form of an agent. But MBA, if their claim was being brought as a subrogated claim, would not be in the room in any real sense. It would not be making any decisions. It might not actually even have a representative there. The party in the room who would be calling the shots would be MSI. That would be the position of subrogation. There's no difference between the two scenarios. So again, if subrogation is permissible, why is not an assignment? And then finally, Malone and Friend dealt with the point, well, how do we get to this route? Is it an implied term or the like? And it's very simple, my lords. You get there by use of the word by. You have the express word. This case is, in one sense, all about that little word, by, what it means. And if you think that an assignment to an insurer by operation of law, which is akin to a subrogation, is not caught by the clause, then that can be because such an assignment is not an assignment by a party. You have the wording there that gets you to what we say is the correct result. My lord, that was all I was going to say in reply submission, unless I can be of any further assistance.
My lords, can I give you one reference, because I'd forgotten it. On the question about the insurance for the ferry flight, is actually dealt with at pages 207 and 208 of the supplementary bundle. There was a request for permission to provide information to insurers, and it was given in relation to the ferry flight. So that was done by express consent.
Thank you.
It doesn't tell you what the contract means, but it's a fact.
No, thank you, Mr. Sanday. Good. Well, thank you both, and your juniors and instructing solicitors and everybody else. It's been an entertaining day, interesting case. We'll take time to consider our judgments. We'll hand them down in the usual way. When we do, please use them only for the purposes of agreeing an order and costs. If you can't agree on orders or costs, we will decide it on paper. And we'll go away now and do our best to find the answer. Thank you.
Court rise, if able.
Very good job. Sorry?